let you know when you get to 15.
Yes, sir. Thank you, Your Honor.
Thank you, counsel. Please proceed.
May it please the court, my name is Andrew Crawford. I'm here on behalf of the appellant in this case, Joseph Zavolnak. This case comes to the court after a conviction and sentence for lewd and lascivious molestation. There are a number of issues that I raised in our initial brief as well as the reply brief. Specifically this morning, I would like to talk with you about the first two issues, which is the prior consistent statements that were introduced through a lead detective, as well as the collateral crimes evidence of the two Williams Rule witnesses. As it relates to the first issue, Mr. Zavolnak was charged with lewd and lascivious molestation. The state filed its notice of intent to introduce Williams Rule evidence through two other students who were in his science class. Specifically, Your Honors, the state was allowed to present these two witnesses. At trial, defense counsel impeached these two witnesses with statements, written statements that they made on January the 13th and again on January the 17th. Specifically, the two Williams Rule witnesses omitted various touchings from those two statements. In response, the state was allowed to call a lead detective who was specifically trained in investigating crimes against children to introduce these prior, quote, consistent statements into evidence. Basically, the defense counsel promptly objected, and I raised this on appeal because there's a number of issues with this. First and foremost, pursuant to Florida statutes 9801 sub 2 sub B, in order to introduce a prior consistent statement, there's got to be a motive, improper motive introduced, improper recent fabrication, or some type of improper influence prior to the prior inconsistent statement or prior consistent statement coming into evidence. In this particular case, the only potential motive or recent fabrication that was introduced was that these two girls omitted the touchings from their statements on January the 13th and again on January the 17th. Now, the Florida Supreme Court has specifically held in two cases that the omission from a statement or a report does not trigger the first prong of the prior inconsistent statements. It's not something that the Florida Supreme Court has held to be recent fabrication, influence, or motive. And the state implicitly recognizes this in their answer brief. The second requirement, which was not met here, is these statements have to be made prior to the alleged motive. The statements that the prosecution admitted to evidence through these two Williams Rule witnesses took place on January the 20th of 2017, not prior to January 13th when this alleged improper motive, if there even is one, arose. So you have two problems with the introduction of these prior consistent statements through these Williams Rule witnesses. The second and more, so having determined that it's error, the next question is, does it raise to the level of harmful error? And in this particular case, and throughout the state, courts have recognized the harmful effect of having a law enforcement officer, especially a trained detective, not just a regular road deputy, but a trained detective who the jury, by the nature of their occupation, gives a great weight of repeating these statements, which is what happened in this particular case, and effectively bolstered the two Williams Rule witnesses, which in turn bolstered the credibility of the complaining witness for which Mr. Zavolnak was on trial. Now, the state cites a couple of cases for the proposition that this is harmless error. And just to be clear, the prosecution below only sought to introduce these statements as prior consistent statements. The First District Court of Appeal had held under limited circumstances that a prior consistent statement can be introduced into evidence, which they held in Monday versus State. Now, in order for the Monday exception to apply, which it doesn't, which I would submit it does not in this particular case, as I argued in the reply brief, the witnesses have to be impeached with the prior inconsistent statement, number one, or they don't distinctly remember making the statement itself. That absolutely did not occur here. Furthermore, when the state seeks to introduce a prior consistent statement to the jury through the Monday exception, the state must, or the trial judge must give a curative, or excuse me, must give a jury instruction about how that statement is to be used. Otherwise, it can compound the prejudice, which is exactly what happened here. There was no instruction given.
Did defense counsel request that instruction?
Defense counsel did not, but there's
Okay.
no obligation in the case law where the defense counsel is supposed to, Your Honor.
But we're dealing with a case where the victim, and I don't think you can deny this, that this particular victim timely reported it the same day to the school and relied upon the school to report it to law enforcement. But this principal shelved, filed away her report for almost 4 years. And it wasn't until these Williams Rule witnesses allege abuse that the alleged abuse for this particular victim is discovered. Is that correct?
That's exactly what happened in trial.
Okay,
Yes, Your Honor.
so there was lots of back and forth about whether defense counsel could impeach them with the statements or not. First of all, we're dealing with Williams Rule witnesses where they are limited. There's always a limited instruction, and this is a trial judge who tried many cases. She was very engaging in this case. I think you have to agree with me. And she made sure that everybody abided by what they were supposed to by pretrial. And the implication by defense counsel is that these two girls are lying. That's the implication. You can call it what you want, but you can call it negative impeachment. Either way, they're conveying to the jury that two girls lied. So now the trial judge is faced with a situation where, should I admit this? If I do, how do I? Am I correct here?
Well, Your Honor, I understand the implication, but merely because someone does not mention something in a statement does not allow the state to introduce, under the guise of prior consistent statements, inadmissible hearsay through a lead detective. The Florida Supreme Court is very clear on this in two cases, in Taylor versus Bradley. You cannot do this, especially through a law enforcement officer.
Well, those are victims in those cases. These are Williams Rule witnesses that are subject to an instruction, and Judge Lay gave that instruction repeatedly. And the state only spent 2 pages in their closing talking about the Williams Rule witnesses. So I'm trying to figure out where the prejudice is here.
Well,
And it
Judge,
wasn't until the state in their rebuttal talked about the Williams Rule witnesses. They didn't mention them in the initial closing. So where's your prejudice?
the prejudice is this, Your Honor, which this court has specifically noted in the Bullington case,
That was a victim.
I understand
That was a victim who read a book. She admitted she read a book about another alleged sex victim who reported it and was taken to a foster home and lived a better life.
I understand.
So
I understand that was.
let's focus on these Williams Rule witnesses.
Your Honor, Williams Rule, one of the worst in trying a case involving lewd and lascivious molestation. Some of the most
Of minors.
Correct. Some of the most powerful evidence is Williams Rule witnesses. I understand that the court gives a limiting instruction. I understand that. Despite that, these are very powerful witnesses. These are not just a witness that observed a car accident. These are Williams Rule witnesses, which the state used to corroborate the testimony of the alleged victim in this particular case. So to say that because it's not a victim, it's not harmful, Your Honor, I'd respectfully disagree. It is harmful because you're almost trying 3 cases within 1 case. Despite the jury giving a limited instruction, these are Williams Rule witnesses who said that this man improperly touched them. Their testimony, their credibility is also an issue. And so when you have a lead detective who is trained in crimes against children, to have him bolster their testimony through the guise of prior consistent statements, which is hearsay, is harmful error. And I'd respectfully submit that it is. It is prejudicial. We're not talking about just a regular witness. We are talking about an integral witness to the state's case. And as the Third District Court of Appeal has repeatedly said in Mendez, the prejudice that flows from someone recounting an act of child molestation or lewd and lascivious molestation based on the societal outrage of sex offenders who perpetrate these type of crimes, the prejudice is especially exacerbated, which I would submit occurred here. That's the first issue that I'd like to discuss. The second issue is the actual collateral crimes evidence itself. Judge Sleet, as you noted, the judge in this case held a long hearing prior to the trial and addressed these collateral crimes that were presented to the jury. Now, one of the things that the judge must ensure is that these are in fact crimes. Again, one of the things that the courts have been especially sensitive to, appellate courts in Florida, is allegations involving purported child molestation. Now, under the statute, in order to introduce other crimes, they have to be either crimes of child molestation or crimes of sexual battery. Now, in this particular case, the state filed a notice, defense counsel filed a motion in limine and sought to exclude these crimes, and then held a hearing. Specifically, there were two Williams Rule witnesses, LS and KB. LS's allegations are especially problematic. The state was allowed to introduce through both Williams Rule witnesses, both LS and KB, that at one particular time, at the beginning of class, she wavered, beginning of class, lunch detention, that Mr. Zavalnek purportedly put his hand close to on her thigh for approximately 5 to 7 seconds. And that's on page 395 of the record. KB said it was not high on the thigh, but it was actually down by her knee. That's on page 354 of the record. Now, this by its very nature is not a crime of child molestation or a crime of sexual battery. Nevertheless, the jury heard about it. The state, mentioned these other touchings in their opening statement during the case itself and during their both of their closing arguments. This is simply not a crime of child molestation. And nevertheless, the state was allowed to hear about it. And that was the thigh touch. The second one was on an LS. Apparently, Mr. Zavalnek allegedly, during a hug, rubbed his fingertips across her breast. On page 402 of the record, she said she wasn't sure that it was intentional. The next touch that she alleged was during a hug. Mr. Zavalnek kept his hands on her pocket area for only 3 seconds during a hug. That's on page 393 of the record. She also thought that was not intentional, and that's on page 401. So not only is a thigh touch not a crime of child molestation, but I would submit that the breast and the butt touch, she didn't think were intentional. Non-intentional touching is not crimes of child molestation.
Well, intent is a question of fact. The judge excluded any allegations or speculation about him rubbing genitalia on the back of their legs, the hoodie string pulling, and any speculation about any provocative acts toward the victims. But the thigh touching that you're talking about is from the same victim who said that he brushed my breast. So don't we have a question of fact as to whether that is a sexual abuse by a teacher who's alone in the room with a student in detention? They don't know each other. They're not playing Foursquare like some of the other cases. They're not relatives like you're helping your daughter up or down or you're putting your hand on her knee to give her advice. This is a teacher alone with a student. And this is a student that is talking about multiple acts. So isn't that a question for the jury?
Before you respond,
Your
Mr. Crawford, we're at 14 and a half.
Yes, Your Honor.
So you know about page 15.
Thank you. Your Honor, first off, Mr. Zavalnek was absolutely not alone during the thigh touch. That was actually supposedly during class, and KB testified to witnessing that. So to clear that up, he was not alone in the classroom with the child at that time. Okay. Furthermore, it's not a question of fact for the jury. The courts have made it clear that the judge is supposed to act as a gatekeeper to try and prevent this type of evidence. And when you hear, when a jury hears about alleged acts of child molestation, it is especially prejudicial to
I have a question, because it seems to me the arguments you're making go to weight, really, not admissibility. And if you remove context, your arguments gain strength. But if you keep the context in, multiple touching, then it does become a question of weight, not admissibility. And the jury gets to give it whatever weight they want, even though the court has the gatekeeping responsibility to begin with.
I understand your position, Judge Vellante. I would just rely upon the arguments that I have in my initial brief as well as my reply brief, and maybe I can address that in more detail during the rebuttal.
Fair enough.
Thank you very much then. We will proceed to the response here in a second. Let me stop the clock from running so that counsel for the appellee has the full 20 minutes. Attorney Sims, you may proceed.
May it please the court, Chelsea Sims for the state of Florida. I want to start with issue 1. As the trial court did recognize, prior consistent statements are admissible as non-hearsay under certain circumstances. As the state did concede in its brief, to clarify what the state conceded in its brief, there was a motive alleged, motive to fabricate. That motive to fabricate alleged was that the students were upset with their grade in the science class. But we do concede that that motive did arise prior to these consistent statements being made. So the state is proceeding under the Tipsy-Coachman doctrine that while they weren't admissible, while the statements weren't admissible as the trial court determined, they were admissible as rehabilitation for after the defense entered inconsistent statements for impeachment purposes. Counsel argued several times that an omission does not equal a motive or recent fabrication. And that's true, but that's not the state's position. The state's position is that these written statements with omissions that were entered as impeachment constitute prior inconsistent statements. And in that case, these prior inconsistent statements are admissible to rehabilitate these Williams Rule witnesses because the defense introduced evidence that the pair gave inconsistent statements. And the state would use Monday and Kitchings as cited in the brief for this proposition. Judge Sleet, as you pointed out, the defense's theory in this case is that the touchings never occurred and the witnesses had a motive to fabricate the allegations against appellant. By arguing that these inconsistent statements existed, the defense was essentially trying to show that these occurrences never occurred, or these instances never occurred. So the state was able to admit this prior consistent statement through the officer to show that not only did these, not to show that these statements occurred, not as substantive evidence that these cases or these instances occurred, but to show that the victims were actually consistent in their statements. The victims did attempt to rehabilitate their own credibility on cross by saying, well, I just didn't give enough detail in those statements, but proceeding under the defense's theory that this omission was an inconsistency, and these inconsistent statements can clarify what these consistent statements can clarify that these inconsistent statements were not actually inconsistent, to show that the victims were continually credible and that these offenses did occur when they said they did. But more importantly, any admission of the officer's very minimal testimony, they simply asked, did KB tell you that he touched her breast? Yes. Did LS tell you that he touched her breast? Yes. These very fleeting, minimal mentions were harmless. Judge Sleet, as you pointed out, all the case law points to prior consistent statements and credibility of victims. In this case, we have Williams Rule witnesses. These Williams Rule witnesses were collateral, and even if there was a minimal boosting of their credibility, we then have to take another layer to say that would have boosted the credibility of DL, who was completely separate from these girls. She didn't know these girls. The instances were not connected in any way other than through the appellant. So to say that a prior consistent statement of a Williams Rule witness words escaping me, so supports the credibility of the actual victim is a stretch in this case. And if you look to this court's opinion in Bullington, this court goes over all the factors for harmless, or all the factors to weigh and the circumstances to weigh for harmless. And this court actually talks about how each case is factual. You have to consider the facts of each case. So while defense does cite multiple cases that find admissions collateral or admission of these prior consistent statements to be not harmless, that doesn't require a finding that's not harmless in this case. Under the facts of this case, it was, like I mentioned, a fleeting mention of the prior consistent statements. And as the brief discusses, the jury's either going to believe the Williams Rule witnesses or they're not. These inconsistent and consistent statements both occurred after a motive to fabricate. And as discussed in Root and Bullington, and actually in Taylor, one of the cases cited by the defense, that leads to a finding of harmless, because the jury's, as I said, the jury's either going to believe the victims or they're not.
The test is that the state has to establish beyond a reasonable doubt that if this improper testimony was in fact improper, that it didn't impact the jury's deliberation. Is that the test under G. Giulio?
Correct, Your Honor.
State has written, okay.
Yeah, and in this case, the state would argue that beyond a reasonable doubt, there's no way that this affected the verdict. As I said, it was a Williams Rule witness, the credibility of Williams Rule witnesses, fleeting mention, and all the other factors weigh in favor of it being harmless. As to issue 2, the collateral crimes, I want to start with counsel's argument that the thigh touching was not a crime. The state would submit that it is. The conduct in question, the witness or the victim, the Williams Rule witness, Kate or LS, testified that she walked up to the teacher's desk, to appellant's desk, and he reached and put his hand, as he was sitting at her desk, on her thigh, just below her butt, and left it there for 5, 6, 7 seconds. Wrapped his hand around her leg, on the back of her thigh, his student. And under Florida Statutes 800.04, subsection 6B, lewd and lascivious conduct is described as conduct that, an intentional touching of a person under 16 in a lewd and lascivious manner. As this court has discussed, there's no statutory definition of lewd and lascivious, but it's generally understood to refer to unlawful indulgence in lust, eager for sexual indulgence, and connotates a wicked, lustful, unchaste, licentious, or sensual design. And in this case, looking at all of these acts in context and discussing all of these acts as the girls described them, touching that thigh, it did have a lewd and lascivious connotation. It was lustful, it was unchaste. It was a teacher touching his student on the back of the thigh, close to her buttocks, as she was standing at his desk. Appellant cites to Leland v. State to argue that this was not a crime. In Leland, Leland was charged with lewd and lascivious molestation of his 12-year-old stepdaughter. And the act in question for that charge was the fact that he was rubbing her legs and her feet and then lifted her dress shirt and kissed the top of her thigh. And he was charged with lewd and lascivious molestation, actually, which is a greater crime than lewd and lascivious conduct. And the state would submit that that is really no different than the teacher touching the back of the thigh in the way that he did. And in Leland, this court did find that the collateral crimes witness evidence should not have come in. But in that case, the facts were that he only touched his 17-year-old stepdaughter on the shoulders, the neck, or sorry, the back, the ears, and the legs, I believe. But there was no allegation of lewd or lascivious touching. And so the touching in this case would be more akin to the charge crime in Leland, which would have been simply kissing the 12-year-old on the thigh. The state or the defense also cites to MLC v. State to say this isn't a crime, but in MLC it was a fleeting touch of a classmate's, but as the defendant walked by, and there was no testimony whatsoever about lewd or lascivious touching. And in this case, that's distinct because we do have the victims that testify that they were uncomfortable by his behavior, that it was inappropriate, that he was handsy with them. And that testimony would distinguish this from MLC. So the state would submit that.
Does this go back to Judge Sleet's prior inquiry regarding the evidence to show the level of intent? That is, the definition of lewd and lascivious, as you read it, is a battery. So it's a battery plus intent of a lewd and lascivious manner, lascivious. And I think it's that juvenile case, if that's the one about the kid on the bus stop touching, the state arrested, there was no other evidence except a passing touch. And if my memory serves me correctly, I authored that opinion.
Yes, Your Honor,
so
you
there's
did.
a little bit more, it's a battery plus, and I think that may have been what the question being propounded by Judge Sleet was trying to explore, that it's not just the touching. And his concern is there other evidence in this case from which the jurors could find from these Williamsville witnesses that the intent for lewd and lascivious was apparent or was present?
Yes, and the state would submit that absolutely in this case. While defense does point out that, I'm not sure if it was KB or LS, testified that they weren't sure that the touching was intentional, what actually happened was they testified that it was intentional. They were crossed and admitted that at one point in time, they weren't sure whether it was an intentional touching, but they were shocked when it happened. And while at first they thought it may not have been intentional, they knew afterwards when they thought about it that it was. And all the evidence taken in context shows that this touching was intentional. For a teacher to walk up to a child and unzip their hoodie, it's inappropriate. It was an intentional touching, and looking at all of the other touchings that this teacher did to these students, he absolutely intentionally touched her breast, and that's for the jury to decide whether or not it was intentional. The touching of the thigh, he wrapped his hand around the back of her leg and touched her thigh as she asked a question. That was intentional. And this intent is a question of fact for the fact finder. And in this case, the fact finder for the Williamsville evidence would have been the judge, not the jury, as counsel argued, as a gatekeeper. But the judge, taking all of these occurrences in context, found that these were permissible. It was clear and convincing evidence that these offenses occurred and that they were similar enough to be admitted as collateral crimes evidence. And Judge Valenti, as you mentioned, defense's argument really is going towards the weight of the crimes and not the admissibility at this point. Keeping everything in context, these were admissible. And the weight is not our question on appeal here. That was for the trial court to decide. I think that's all I had as far as notes. Are there any further questions on issue 1 or 2?
It does not appear from my scan of the screen.
Okay, then the state would rest on its briefs at this point.
Thank you, counsel. All right. Okay, Mr. Crawford, you have 4 minutes remaining.
Thank you, Your Honor. We have heard that the state has now essentially conceded that these statements were admitted potentially in error. So the question for this court would be whether it's harmful or harmless error. Now, in the state's brief, they cite to Bullington, Bullington is completely distinguishable from the instant case based on the voluminous evidence which appeared in Bullington, which is what the court relied on, the panel of this court relied on in making that determination. In Bullington, there was evidence of child pornography of the victim on the defendant's phone. During a exam, there was scarring consistent with child molestation. Furthermore, there was the child's testimony as well as a whole host of other evidence, which did not appear here. There was no physical evidence, no medical evidence. The only evidence in this particular case was the statement from the complainant for which Mr. Zavalnak was on trial and the 2 Williams Rule witnesses. Case law from this court, as well as throughout the state of Florida, has uniformly held that evidence that comes through which bolsters the testimony of, I would submit, Williams Rule witnesses, which were an integral part of the state's case, is harmful and reversible error, and the prejudice is exacerbated when it comes through a law enforcement officer, in this case, a trained detective.
Well, the defense counsel decided to, I guess he should have picked his words differently, but on LS, when he crossed her at 402, he said, you actually never reported these incidents, correct? Never reported. He knew she did, but he asked that question. He stepped in it. He opened the door saying she never reported it. What say you to that?
Judge, in candor, I don't see how that applies whatsoever to the first issue on appeal. He did not open the door to the state entering into evidence under the guise of prior consistent statement, hearsay evidence to bolster their credibility. Furthermore, that was never argued at the court below or on appeal.
Oh, the trial judge made a comment that he accused her of never reporting it. That's one of the reasons why she let it in through Detective Sharp. Plus, this is the same attorney who crossed the mother and said, you'll accept money from the school board if it's offered, won't you? That was objected to. That's improper. Same attorney argued on closing. This is all about money. This is all about hiring a PI lawyer, suing a school board and getting money. Well, she sued the school board because they took 4 years to pull that report out of the file. So you tell me about prejudice. Where's the prejudice when your co-counsel's arguing that below? That's improper.
Judge, I wasn't that lawyer.
I know you weren't, but you're vouching for him.
That's not what I'm attempting to do here.
You're arguing on behalf of your client. We'll go from there. How's that?
Let's do that, because that's what I'm attempting to do. I am not vouching for that type of argument. Now,
but we're weighing the prejudice. This is a serious case. Don't get me wrong. We appreciate the seriousness of this case and the charges. We really do. We were all trial judges, so don't get me wrong. I don't want you to think that. But this is an abuse of discretion standard. We have to find that no other judge would have done this. So help us with that.
Understand, Your Honor.
And if you would weave into your response, the state's argument is that there was a discretionary ability to use the prior consistent statement. And I think that standard, if it's proper to do that, would be abuse of discretion. So these may be interrelated. So if you would, if you have the time, and since I got the clock, I think you'll have the time, address that for me.
Certainly. Your Honor, Your Honors, in this particular case, it is abuse. I understand the standard is abuse of discretion. What we have here.
But the law creates barriers there.
They do. They certainly create barriers under abuse of discretion. In this particular case, what the court is referring to is the Monday exception, which the First District Court of Appeal cited originally, and then which was followed up with the Kitchings case. In order to properly exercise discretion, this is a narrow exception, which has no foundation in actually the statute, but is judicially created. The court makes it clear in both Monday and Kitchings that this is a narrowly tailored exception, and trial courts are not, it's not supposed to swallow the languages, the general rule that prior consistent statements are generally inadmissible when a witnesses' credibility is attacked by counsel and should only be admitted when they're impeached with a prior inconsistent statement or when they forget about both of those statements and the court is required to give a limiting instruction. Otherwise, it compounds the error, which is precisely what occurred here. Furthermore, the abuse of discretion was further abused because you have to look at how and who repeated the statements, which were repeating of the statements, which is what the Kitchings and the Monday exception say you cannot do, which is exactly what occurred here. Again, I can't overemphasize that there was no physical evidence, no medical evidence, unlike Bullington. And the state utilized a lead detective trains against crimes against children to introduce these statements into evidence, which every court throughout the state of Florida has uniformly held enhances the prejudice. I'd just like to talk briefly, I know I'm limited on time, in terms of the thigh touch. I'd respectfully disagree with opposing counsel's rendition of the thigh touch. It was not up toward her buttocks. KB specifically said the thigh touch was by her knee. That's on page 354 of the record. So it's not up by this child's buttocks. Furthermore, Judge Casanueva, you authored Leland, Foreman, and MLC.
I noticed that as I went through that, and I would have to tell you, you guys missed one. I also authored Hebel.
I'd respectfully submit, based on those cases, that this was more akin to a non-intentional touching. It was not a crime of child abuse. I understand that the court is a gatekeeping function, but keeping things in perspective, when you have the charged crime, which has no physical evidence whatsoever, no medical evidence whatsoever, no forensic evidence whatsoever, Williams Rule witnesses are incredibly powerful. Introducing purported crimes of other child molestation is especially harmful, according to the Mendez case. I'd respectfully ask that this court reverse and remand for a new trial and would rely on the other arguments contained within the amended initial brief and reply brief.
Thank you. Unless, I don't want to lead you astray, Hebel is a prior consistent statement case. It's only about 20 years old, but you made me remember it. So I thank you. I got to go back through the archives a little further. Thank you. Well argued, and
Thank you.